I write a blog, and I don't take any ownership claim on its contents, and I do it for free. Just because I find value to do it for myself.
And I copy it and put Google AdWords on it, you're going to be totally cool with that?
Totally cool with that.
Because I can do that when I get home.
You certainly can. And I would hope that the replication of my work would lead people to find the original.
Well, I wouldn't attribute it.
He has the...
You don't have to, because when people look, do search terms, my version will show up beside yours.
No, I'm sure I can see it.
She'll crush you.
That's fine, because then people are reading my ideas, and it's the ideas I want to have spread.
Okay, I have a question. How will it work under your system, say in education? I'm at a university, and the instructor or what else are they called?
Professor?
The professor says, I want you to do a report on the Civil War. And I see somebody's report already done in the internet, and I say, okay, well, this is mine, and I put my name on it, and I turn it in to the professor. How would that do anything wrong? Whoever wants to answer that.
You have two scenarios on that. One is, did you buy the report from the person on the internet, or did you steal the report from the person on the internet, or copy it without their knowledge or permission? Because those are both options available.
All right, let's say I bought it. Okay, I bought it, but I didn't tell the instructor.
You licensed a copy from the original creator
Right.
for the use that you wanted to put it to. So everything is fine from a intellectual property perspective. But you might get in trouble if the instructor has seen that same report 5 times because everyone else in the class got the same one.
All right, so then it would be
Now,
wrong.
if you go to a specific site on the internet and you say, I've got a report on this subject matter and I'd like to hire you to write that report for me as a work for hire, you own that report because you hired someone to do it as a work for hire. So they can't sell it to someone else without infringing on your copyright on the work.
Right.
So then you know it's unique, and your professor is less likely to bust you for copying something, but you're still going to fail the test. Because
I just want to point out what's wrong in this situation is that the student has violated a compact of trust with the professor by using work that somebody else had created and claiming it as their own. They are engaging in plagiarism, which is a specific type of fraud. And that breach of contract between the student and the professor is completely independent of copyright issues. That's a case of fraud.
Right. I just want to say this. My concern would be, I'm in medical school, studying to be a medical doctor, and I'm getting reports. You know, I'm doing it the right way. I'm buying it from someone else. Then when I graduate, I mean, am I ready to be a doctor, or is it just some other doctor giving me the information for me to turn into the professor? I mean,
copyright and intellectual property have nothing to do with whether or not you're a dishonest student. It has no effect on it. The only effect is whether or not the person whose report you originally used goes after you for using their work. That is the only way the copyright or intellectual property comes into that equation. It has nothing to do with the professor, has nothing to do with the school.
All right.
Now, someone may be able to make a case that if you were in a classroom and someone was doing a test and you copied over their shoulder, maybe that is an infringement of their intellectual property. But that's, you know.
Okay. You're going to get tried for fraud, though, not copyright
fraud. Okay, now I have to ask this. What is the purpose of a boundary? And if that purpose is so that we will know what is a person's property and what is not that person's property, if the purpose of a boundary is to know what is and is not that property, then how is that any different from a song or a dramatic work if we can recognize what is and what is not that song or dramatic work or other creative work?
Well, the fact that we can distinguish songs from each other, and my ability to distinguish two chairs apart, isn't a problem.
I agree.
I mean, in that particular sense, the intangible good and the physical goods are behaving in the same way.
Okay, I agree. So how does the existence or non-existence of a boundary, a tangible thing, I mean, if we can tell what is and is not a tangible thing, and base property rights on that, then why shouldn't we be able to base property rights on an intangible thing if we can tell what is and is not that thing?
So, the purpose of boundaries allow us to draw lines between goods?
To know what is and is not.
Yes, to distinguish two goods apart from each other, and to distinguish lines of trespass. So, I would argue that a picture or something like that, if it's not encrypted or anything special, has no boundary law around it. Yes, we can distinguish two pictures apart, but there's nothing to let me know that I'm harming you when I make a copy of something I've seen.
Well, harm is a separate issue.
I'm
just asking about the issue of a boundary and definition.
But if you're making a property claim, then you are claiming that when I duplicate a work, I have transgressed in some way.
Yes.
Against a property claim.
Yes.
What property is being claimed?
Well, what property is being claimed is my work and my use of that work and my right to determine, my exclusive right if I'm the sole owner, to determine what happens with that work and how it's used or disposed of. I mean, that's what ownership is the exclusive right to determine how something is used.
I'm going to turn this around to Forrest with a question that I wanted to ask. So, with physical goods, we recognize property because of exclusive use. If I'm sitting in a chair, nobody else can be sitting in the same chair.
You sure about that?
In this universe.
Right? In this universe, if I'm occupying a space, nobody else can be occupying that space. And then we extend these ideas to I own my car and I own my house even though I'm not
From a
currently
libertarian
sitting inside them.
non-aggression perspective.
And so I was wondering, when I duplicate a piece of work, where is my transgression there? How am I preventing you from using the original?
Show of hands, who believes people own their own time?
You are diluting the value of that work, and that doesn't necessarily have to harm me. It could help me, but I could not want that help. I could not want my work sprayed all over the internet by you. It could be between me and my friends, and that should be my right. So there are many exposure areas. I have, say if I am a photographer and I take a picture and someone says, well, my band's really stressy about how we're presented. So you can use that picture in your magazine, but I don't want it in anyone else's magazine. I can make that agreement with that person and say, I know that I'm pretty sure I'm going to be able to make sure that it's only in the thing that's here. And we can come to an agreement between people.
Privately, you can, yes.
But if
I'm
you
not going
take
to dispute that.
if you take that picture and you spray it all over the internet because you think it's cool, that hurts me and my integrity and my agreement with that person.
But I was not party to your agreement. I mean, your contract
But nothing
doesn't
should
bind the
imply
third
to
party.
you that you have the right to do that in the first place.
Except for the fact that I don't recognize, I still have not had it fully explained to me how I hurt you when I duplicate
I
work.
just explained it.
If you
Five
work
to
for
3
3 hours,
You're
you get
making an
nothing.
ownership claim over a market value of a good.
No,
Right? If-
the intellectual property is what I'm
No, because you said when I duplicate stuff, it lowers the market value of the good.
That is one way that it harms me, because your question is harm.
But in what other circumstance would you claim a market value? Would you claim to own market value? Because you can't. A market value is a market thing.
In the example that I just stated, my argument was not that you diminish the value of that picture. My argument was that you diminish the value of my integrity and my agreement with the
But as a third party, I was not involved in this agreement, in its setup or signage or anything.
The social compact is that you know that you shouldn't take it.
How would I know? What order lets me know? Because some books are copyable and other books aren't. What lets me know?
And this gets back to your question about borders. Prior to 1989 or whatever year that we decided to adopt the U.S. version of the Berne Convention, you had to mark copyright and intellectual property. You had to put your little circle C or your circle P if it was a phonograph. And Berne Convention, I think, kind of confused matters a little bit by saying that you don't have to mark them. So people can now claim they didn't know that you were protecting that object or whatever. But the upside of that is that when you create the work, it is protected. You don't have to go and register it and all of that sort of thing. When you create it, so that's the trade-off, is that not having gone through the work to do the proper format and marking makes it harder to track, but it brings the protection closer to you as an individual. Now you can still register that so that there are specific damages that are already enumerated per use and that sort of thing. And then you do put your little symbol on it and all that sort of thing. So you can establish territorial borders, or you cannot establish territorial borders, and you would be relying on common sense for someone to know that this is 2 songs instead of 1 song. So if I stole it, I stole 2 songs and not 1 song, or 3 photographs instead of 1 photograph. This actually causes me a little bit of stress because I've got hundreds of thousands of pictures on the internet. So if I want to register those, that is unbelievably arduous. And I feel that I am owed the actual damages, registered damages, standard, whatever, but wow, that's a lot of work for me. And so they have to catch the systems up for how to register things. A performing artist can register a song, but if they had 100,000 songs and they had to fill out a piece of paperwork for everyone, it would be like, doable. So it just depends on the format. But borders are sort of optional. Hopefully that addresses your issue.
All right. I think it's Forrest's turn to ask a question. If he has one, or I can shout out a question for you.
I do question I want to shout out.
Yeah.
I'll take other people's questions because I kind of get the gist of Eric believes that the government should not recognize copyright.
Oh no, I don't recognize the government. That's a different thing. It's that I don't recognize the government's ability to stop me from rearranging physical matter that I own in ways that please me. So if I see something and I replicate it using my own labor and my own property, then I still own that property after I've labored on it, even though it may just happen to be a copy of something that you had made.
So I guess my question would be, do you believe that your view should be forced on everyone else?
No, but I don't think that your view should be forced on me. And you
My view isn't.
No, it is. You want to claim that you own the photograph, not the physical one that you made, but the image itself. And if I were to reconstruct that in my computer and print it out on my paper, then you will have the government come and take it away. You will claim physical damages, or you will make a claim to the government of copyright infringement, and that will be enforced in a physical way against me for an intangible thing that you claim. Now, if you can enforce copyright with an intangible mechanism, then I'd be for that, right? Because I would pay you intangibles for a transgression on intangible goods. But I don't think you can make that claim. You're getting money or something else of physical value from me.
An interesting case on this was when cable television came along. One of the first things they did was utilize broadcast television's airwaves to push broadcast television shows to new audiences. They felt that they weren't infringing on the value of the broadcast television, and they were not copying it because they were capturing it out of the air. This was, in court, determined to be actually not a fair use of the product. And what was put into place was standard licensing fees. So the government didn't have to go and kick in the doors of the cable company and force them to stop. They just said, you know what, if you pay these guys a licensing fee, we're all good.
Well, then they did threaten to shut them down and pay a fee. They are stealing money then.
But you're saying someone would have to come to your house and force you to whatever.
And they did it, legally.
You don't.
Through a legal mechanism, they did just that.
Okay.
So here's my question. Under what circumstances does somebody own their time and deserve to get some kind of reward or recompense for what they do with their time? Is it something where if a large corporation hires you and they've done all their complicated forecasting and decided beforehand what your hours are worth, so you have a contract with a big corporation on what they're going to pay you, then it's okay for you to get compensated. But independent businesses should not be able to put a value on their time?
Well, how is time an intangible good?
Time is what goes into creating an intangible good.
Yes, it does.
Time is what goes into work.
Time does go into work, yes.
So is the only time
But-
you should get paid for your work if you're working for a large corporation who has predetermined some contract with you on what they're going to pay you?
Well, the large corporation can pay their employees to do a lot of work that comes for naught in the market and then go bankrupt.
Let's say it's
The fact that they expended effort is no reason to give them money.
But if they do that effort, even if it's useless, as long as they have a contract with a large corporation that makes a bunch of money.
Oh,
from
you're
physical
not
objects,
saying the
then
corporation
they should
goes
get-
bankrupt.
But most large corporations don't go bankrupt.
Agreed, because they diversify their assets and make sure they have steady revenues, yes. But that's business acumen.
Basically, independent businesses where they don't know the future value of their labor, they're expecting the market to actually rate price it in a fair way. They don't deserve to get paid. It's
No.
okay if they get nothing.
Nobody can make an ownership claim on how the market will value a good. You can make an agreement with an insurance company that they will pay you some amount if things don't come the way that you expected. But I'm betting the insurance company wants the money up front for that agreement.
So that's thumbs up on large corporations, thumbs up on insurance companies, thumbs down on small business?
Absolutely not. All three can go bankrupt, and the small business can profit.
But isn't the property owner with the greatest access to capital the most likely then to be the beneficiaries of what we're calling copyright?
Yes. So in the very beginning, I did state that I thought Forrest had a burden of proof here, because he wants to prevent me from duplicating work, which cost me maybe a little bit of time, but I'm definitely using only my own resources in order to duplicate works. So I'm using only my own property. He wants to prevent a certain action of mine on my own property.
My question was, is his time not a resource?
His time is a resource, but
You should get it for free.
I am not obligated to give him money for how he spends his time. He can spend it destructively or productively. I'm not obligated to give him money either way.
And my original statement was that my creation has intrinsic value proven by your desire for my...
That's a market value when you sell me the good. But you don't have an ownership claim on market values, because I could own a whole bunch of gold, and then somebody gets the philosopher's stone, and then my gold is suddenly worthless. Do I sue them? No. That's ridiculous.
You get to sell one copy and it better be for a high price. And sell it to Walmart because they're the one who can make the most money on it.
I think that in
That's the
England
only
and
model
in
that
France,
works on that.
they tried the model where the individual artist didn't get compensation for their work, and it stifled the work.
But
So as a society,
I
we
don't-
support giving the individual the value of that work.
well, as a
We don't
counter,
have to,
as-
but we choose to.
as a counter example, let me name a bunch of fields which do not recognize copyright that are continuously producing new and innovative works. There's fashion, food recipes, and
Fashion
food
has
appearance.
copyright.
Fashion doesn't have design copyright.
They have textile copyright.
Well, they've had textile copyright for a long time, but they don't have any claim of ownership on designs.
On the garment design, yeah. That's true.
They have no claim of ownership on the design of the garment. That can be replicated freely. Food recipes and appearances on the plate. Automobile sculptural design. Generally, they're all pretty similar because of aerodynamic reasons. Furniture, magic tricks, hairdos, open source software, tattoos, jokes, fireworks displays, rules of board games, scents of perfume, compositions of mutual funds. All of these things have no copyright claim on them.
I would contend that some should.
I believe that
If this is
tattoos
original, why
have.
shouldn't it?
I believe that tattoos have actually successfully.
That would be new. That would be fairly recent.
Well, it's new technology.
Okay, I have a question. You gave the list, and why is it that Mattel keeps suing board game manufacturers who make board games that look like Monopoly? Why do they keep
That's a case of trademark, not copyright.
Still IP.
Yeah.
Yes, but where's
Very
the copyright
different,
tonight?
yeah, very different rationale.
I understand, but it's still intellectual property. It's still an intangible.
Well, you can
And that's
generalize
how
my
the-
position.
and that's how the-
Against intellectual
trademark.
property.
And that's how the
I don't
clothing
think it's
label
property.
goes against handbag knockoffs is on,
But yeah, that one's trademark.
which is also valuable.
I would disagree there. Trademark's not valid, and you can get partially there with cases of fraud. If somebody buys one good versus another good under the impression that it was, like I buy a generic box of tissues under the impression that it's Kleenexes, and then I've been infringed because I've taken an action under fraudulent information. So the consumer has the right to prosecute these things.
I guess-
not companies.
My entire vocation is based on intellectual property. Everything that I produce, I'm a photographer, I'm a designer, I'm a publisher, everything I do.
Yes.
My entire livelihood is intellectual property. So without any intellectual property, then I have no.
But your failed business model is not my problem.
But then I'm going to have to come steal your gold.
No, you won't.
And that's generally bad for society.
You can find different ways of getting money
Better than stealing your gold?
better than stealing my gold. Yes, absolutely. There are plenty of people employed in different fields.
All right, well, we've
No,
been going
my
for an
skill
hour
set.
and 20
Okay,
minutes.
I have one final question. I must ask this.
So-
Hold on, I have to ask.
I want to take my ball and go home.
All right. Let's say we had your system, no government, anarchy, and all that kind of stuff.
Which is
All right.
why libertarians should not support it,
Well,
because
I
they're
don't.
not
but-
anarchists
All right,
necessarily.
let's say we did.
I'm an extreme.
All right, let's say the history of this landmass known as the U.S. was different. And way back when Tom Sawyer, Huckleberry Finn was, Samuel Clemens did his thing, and we didn't have any government or anything. All right, and you decided to copy it and give it away or whatever you did. Should we think less of you for doing that? In other words, should I think less of a person who were to copy, Harry Potter and the Sorcerer's Stone and
Well,
sell it? Or should I think more highly of the author of
Right.
Harry Potter, the original author?
Historically, before copyright really came into vogue, artists were producing works, and those works were replicable. But but the artists were generally recognized when their work got copied. So if one musical composer copied little pieces from another musical composer, that would actually considered a very high compliment, not theft.
Okay, I don't buy it. I don't buy it.
So I notice in our language we don't have any specific word for theft through the act of replication. There just is no word for it.
Dilution.
Dilution is a market value term, but if I were to duplicate photographs, you wouldn't say that I was diluting the photograph. And
I actually have more questions too, but I feel like we're going.
Yeah, I just want to say one final thing. The copyright for Huckleberry, not trademark, the copyright for Huckleberry Finn and all his other works, it's already over. So anyone can do a different version. And this professor decided, well, I'm going to do a different version and take out all these politically incorrect offensive words, which he did, like Negro and Indian and all that. So he took them out, and and he substituted some other word, generic word. I think less of him than the original author of Tom Sawyer.
For passing it off as his own work?
No, for deciding that he was going to be politically correct and take out words like Negro and Indian and all that stuff.
Okay.
That he was sanitizing.
Because he
So
made
you just value the derivative work less than the original, and that's fine.
No,
That's
it's not the
market.
work. The person, the author of the derivative work, I think less of him than I do Samuel Clemens.
That's fine too.
That's fine. So, you can get 6 minutes to wrap up, or whatever you think is reasonable. We've touched on a lot of questions here, and everybody remains civil, so I commend you both for not taking it personally. I've learned stuff, so I really appreciate you guys putting the work into it. So, Forrest, if you want to do 6 minutes, and then Eric, you've got the last word.
That's quite an honor.
Well, mostly I appreciate the opportunity to debate in this format, and I look forward to future debates, and hopefully we'll get the format a little bit, wired up. It's certainly been fun, and I do appreciate your view as being yours. I would not, at this point, I would say that I'm not convinced that a libertarian should not consider copyright to be property. I feel that it is for the good. It's good for the free market. It's good for creativity within the society, and I don't think that it hurts the libertarian.
Close the register. You can sit over here, whatever time.
Okay.
But I
Yeah,
just close the register.
All right, you can bring the bills.
I don't feel like it hurts the libertarian platform to recognize copyright as property, personally. But I say that respectfully, and that's pretty much my position.
You're all going to think a lot less of me now. I liked, when we broke the format and just went into free form, I got the most fun out of that. It must be that as an anarchist, I kind of revel in the absence of structure and a little bit of chaos. The debate's been wonderful. I really like the audience participation. That's also been good too. And now you're all going to think a little bit less of me, because all the notes in front of me were not actually mine. I got them from Stefan Kinsella by watching a video of his online and just writing down pieces out of his slides and other information. So he puts this stuff up there for free, and I can promote his work.
I don't know how that translates into thinking less of you.
I think you're consistent.
Because he was trying to pass that as his own work and it was somebody else's. That's why.
I want to name a couple of the resources. So one is I used Kinsella's resource. He has a website, C4SIF, the Center for Information. I should have wrote down the F, didn't I? But C4SIF.org/resources had a long list of articles and whatnot. Bolden and Levine have written a wonderful book called Against Intellectual Monopoly, which goes through case by case of different fields where the intellectual property laws have actually hurt those fields. And Mises.org has a page on Without Intellectual Monopoly, which also lists some alternative business models that you might want to use, that every creative author might want to use.
I don't think that a creative person should be forced to use alternative business models because someone values the core creation of theirs so much that they shouldn't get it themselves.
That's a plea for government protectionism. All right.
Actually, it's a plea for people understanding the artist's perspective. Because usually what you want as an artist is for someone to be cool, not for the government to come in with Japanese.
But we are out of time, so thank you all.